Hi, thanks for joining us. This is the Real Estate Forum, and my name is Michael Spurr. In this episode, we're going to talk about owning investment property, specifically residential investment property. You have to treat it like a business. You have to understand and accept the risks. With any investment, there's also risk. So we're going to talk about filing a summary process, or commonly known as an eviction. You might ask, how much does it cost? And how long should it take? We're going to dive into this and more with my guest, Alexis Kenny, attorney at law. Hi, Alexis. Thanks for joining us.
Thank you so much for having me. Happy to be here.
So, why don't you tell the viewers a little bit about yourself and how this all started?
Sure. So my name's Alexis, as you said. Thank you for the introduction. I grew up in Boston. I attended Boston Latin Academy for high school, graduated in 2015 from there. Very fortunate to be selected as a Thomas M. Menino Scholar, which was essentially a full tuition merit-based scholarship to Boston University.
Wait, you went to Boston Latin,
Academy.
which is Academy.
Yes.
And then you got the scholarship?
Yes, correct. I think.
So as they would say in Boston, you're wicked smart.
I like to think of myself as fortunate, but thank you. Thank you very much.
So then you went on to college. Where did you go to college?
Yes. I went to Boston University.
Great school.
Yeah, had a wonderful experience there. Very fortunate, like I said, to be on a full tuition merit-based scholarship that was given to graduating seniors in the Boston public school system.
Sure.
So that was absolutely wonderful. Graduated magna cum laude in 2019 from BU.
Nice.
And then went straight through to law school.
Where'd you study law?
I studied at Quinnipiac University in Connecticut.
Sure.
Again, very, very fortunate again. I was also awarded a full tuition merit-based scholarship to law school.
Way to go.
So that was, a huge relief for me and my family.
Well, so many people struggle with educational debt.
Absolutely.
Today.
Absolutely. So I feel very lucky to have been able to have avoided that.
Sure. You practice real estate law, more specifically landlord-tenant
Correct. Yep.
law. Why that particular area?
So, my experience in Massachusetts is that it's pretty tenant friendly. And what I find, gives me a lot of joy and fulfillment is that I like to help out the mom and pop type of landlords who might be underdogs.
Right.
It can be a very difficult court process, or navigating the court process can be very difficult for, your average everyday landlord. So
And it's, as you know, I'm in real estate, and in my 30-year career, it's very easy to have a situation snowball on you.
Absolutely. They can get out of hand very quickly. I've seen, landlords who are in the hole tens of thousands of dollars.
Right.
Just all it takes is one not so great tenant, unfortunately. And
Well, let's for our viewers and for this episode, let's role play a little bit.
Sure.
I'm a landlord. I have a tenant, a single occupant gentleman. He's been a couple of years, usually a couple days late with the rent, but nothing serious. He has a lease. He doesn't have any pets. It's just him. And I noticed that the rent is more than a week late. He hasn't contacted me. I reached out to him. I texted him. He didn't get back to me. What would be your advice?
Yeah, so that's, a tough situation, of course. So my presumption is that you as the landlord, you're more interested in terminating the tenancy than essentially restoring it. Is that correct?
Yes.
Okay.
Let's say he gets back to me and he's lost his job.
Right.
And no fault of his own, he was laid off, but it doesn't look promising, and I'm very nervous about him paying rent, and I want to move forward.
Absolutely. So your first step would be to have a notice to quit drafted and then served upon him.
Okay.
So a notice to quit is the document that we send out to tenants that essentially terminates a tenancy.
Can I just write a note and say I'm ending your tenancy?
I advise you not to.
Okay, so
just
there's a
because-
specific form.
Absolutely, absolutely.
Okay.
A notice to quit has to contain specific provisions.
Okay.
You know, you need to name yourself as the landlord, you need to name the tenant, you need to name the property, the premises,
Okay,
so the
yep.
address, everything has to be, you know, clearly identified. I've seen landlords run into trouble.
By not doing it correctly?
Correct,
Yep.
correct. And you're going to want to have specific language in there as well that essentially says that, you know, any funds that are paid after the notice to quit will not be accepted as rent,
Okay.
but would rather be only construed as use and occupancy and will not reinstate a tenancy.
I see.
So it's
Okay.
very important to get that in there. I've seen a lot of times landlords, you know, fail to put that provision in there, and if a tenant tenders rent and the landlord hasn't reserved his or her rights, a lot of times a court might say, well, you've reinstated the tenancy and
Right, I
dismiss
see.
the case. So that's a common pitfall.
Okay. How should I go about having the tenant notified or served?
Great question. So though there is no legal requirement, you almost always want to have it served via a constable or a sheriff.
Okay.
And that is because a constable or a sheriff will attach an affidavit to their return of service saying, here's the date and time I served the tenant, here's the manner I served the tenant, if he was served in hand or a true and attested copy was left at the last and usual place of abode
I see.
with a first class copy thereafter.
So if it's served by a constable or sheriff, a tenant can't say, I'm sorry, Your Honor, I never received it.
It's a lot harder for a tenant to say that.
Okay.
So a constable or sheriff's affidavit of service is prima facie evidence for the landlord that the tenant received it.
Okay.
So the tenant would then have the burden in a court of law to prove that despite the constable or sheriff's affidavit, that they still didn't get that. And I've yet to see a tenant
Okay.
successfully claim that.
Okay, sure. So the tenant receives the notice. Can they respond to this? Can they argue it? What?
Yeah, so it's not uncommon for, you know, if I serve a notice to quit for one of my clients, and as an attorney, I sign it with my contact information, so
Yes.
my email, my phone number. It's not uncommon for me to get emails or calls from
Right.
tenants saying, well, your client did XYZ and I'm not paying rent because XYZ.
Right.
You know, you got to kind of let that roll off your back as an attorney. What the tenant will have the opportunity to do is present any defenses or counterclaims he or she may have in a
Right.
court of law.
Okay. So this gentleman stopped paying rent. I have him served. How much does that having him served usually cost?
So it depends on the constable or sheriff you use, and it depends on, you know, how far that individual actually has to travel
Okay. That makes sense.
to make service. In my experience, it's typically between $60 and $90
Okay.
for service of a document.
Let me ask you this. To start the process, what do you generally, if I was going to hire you to represent me, what do you generally estimate the cost would be for just getting the process started?
So if we're not going to talk about legal fees, if you just want to talk about service and court costs, I typically advise my clients to expect to spend total around $400.
Okay.
Again, that's exclusive of attorney's fees and you know,
Right.
your lawyer's fees. That's
Yep.
just the cost for me to hire the constable or sheriff to make service of the notice to quit, summons and complaint. It's the
Yep.
cost to electronically file in court.
Okay. So I can come to you and you'll do that, all that stuff for $400, give or take.
I'll do it and then I'll bill you for it as my firm incurs those
Okay.
costs.
Okay.
Essentially.
I see.
Yeah.
Okay. We've done that. Then the next step is what?
So after you've served the notice to quit,
Yep.
you want to make sure you're waiting the amount of the requisite period of time and then you're going to want to serve a summons and complaint.
Okay.
So let's assume that in your scenario here, we've served a 14-day notice to quit for non-payment of rent. So that means 14 days after the tenant receives the notice to quit, the tenancy is terminated.
Okay, so it's a 14-day notice to quit after he was served,
Correct.
not
Correct.
from the first of the month when he was late.
Absolutely correct.
Okay, so it's important to do that
It's
quickly.
important to keep. It's important to do that quickly. It's also important to keep track of dates.
Okay.
Because let's say you serve the summons and complaint on the 13th day, a court can throw that out if you file and dismiss.
Oh, on the 13th day
If you serve that summons and complaint too early, the court can say you did not properly terminate the tenancy and dismiss your action. So
I understand. So
yeah.
you have to wait the 14 days
correct.
and then file.
Or then you want to serve your summons and complaint.
Let me make sure I understand this correctly. If he's 1 day late, I can file the 14-day notice to quit.
You serve him with the 14-day notice to quit, correct?
Okay.
You wait so 14 days after he was served, and that's
I
why
understand now. Okay.
That's why the
Yep,
return
yep,
of
yep,
service
yep.
is so important as
Right.
well.
Okay. Got it.
So 14 days after he was served, let's say he was served on the 2nd.
Yep.
So on the 16th, you can start filling out what's called your summons and complaint.
Okay.
So that costs $5.
Yep.
We get them from the court. I'll fill it out if I'm your attorney. It lists you as the landlord.
Yep.
It lists the tenant. It lists the address of the subject property.
The amount of
also,
arrears. Yep.
Correct. It'll include what's called an account annexed, which says, late December, $1,000.
Yep.
January, $1,000. And then we add that up. I'll sign it, put my contact information on it, and then we serve that as well.
Okay.
On the tenant, again, via constable or sheriff.
Okay. Is it important to use the same constable as sheriff?
I would. Again, not a requirement, but just I think it's important to have, a forward-thinking procedure. Let's say
Keep things consistent.
correct.
Correct.
Yeah, like let's say you have a tenant who goes rogue and wants to drag this out as long as possible, and
But that never
gets to
happens.
court. I wish. If you get a tenant that just wants to drag this out as long
Yep.
as possible, you may need to subpoena your process server to come
True.
testify in court. So it just gets messy if you used one individual for the summons and complaint, another company for the
Right,
notice to
right.
quit.
If you keep it consistent, it's that one person.
Correct. Correct.
And that person also is going to be probably more attuned to the situation.
Absolutely.
Okay.
Absolutely.
So we've done that and we end up in court. We have a hearing. Tell us about that.
Yeah. So in housing court, the first hearing is called a Tier 1.
Now you said housing court.
Sure.
There's the regular district court and housing court. They're two different.
Correct. They're
Okay.
two different courts. You could file a summary process in either court.
Okay.
My preference is housing court.
I've heard that that's not as friendly or a tougher.
Towards landlords?
Yeah.
I understand that. I tend to disagree. I think housing court is, in my opinion, the right place to start. And that's just because if, time is really of the essence when we're dealing with evictions, right? And
Yes.
getting tenants
Yep.
out. So a tenant, if you file this in district court, a tenant who knows enough can delay the process by removing it out of district court and putting it into housing court. That's called a transfer.
I see.
So that does,
Now, if you go into housing court, can the tenant do the same thing back to district
No.
court?
no,
Okay. So housing court is a one and done.
correct,
Okay.
correct. And also, this brings me into what you just asked me about. A Tier 1 mediation is the first event in a housing court, summary
Okay.
process complaint. And I cannot say enough good things about the housing court staff. And
Really?
in every housing court across the Commonwealth, from Eastern to Western, from Boston to the Berkshires, There are housing specialists.
And say more about that. Why
Sure.
do you say that?
Why do I say?
That enough about the mediation and the staffing.
Right. So as I said, the first event is a mediation.
Okay.
And
So if I understand that correctly, you're not going in front of a judge.
correct.
Okay.
You're sitting down with a housing specialist who's essentially a neutral third-party court employee. And in housing court, like I said, they're absolutely fantastic. This gives the landlord and tenant the opportunity to sit down and talk about the tenancy. I absolutely recommend for my clients, if we can come to an agreement at the first tier event, that's almost always the best path for a landlord.
Okay.
And
why
that's
do you say
because-
that? Why is that?
Yeah, great question. That's because in a mediation, the parties have way more flexibility
Okay.
than, say they were just going to go in front of a judge. And if they went in front of a judge, the judge is going to say, okay, one party gets possession, the other party doesn't.
Okay.
However, in a mediation,
So
we
almost a
can-
winner take all.
Correct. Exactly. In a mediation, you can talk to the tenant, especially if it's, a good tenant that's just having some difficulty. You could
Right.
say, well, could you be out in 45 days? You have discussions and
Right.
see if there's, some common ground between you two. And a lot of times there are.
Right.
There is this common ground. And, you've heard me talk about this before, but once you come to an agreement, the housing specialist will help you write it up right then
Okay.
and there on the spot. And he or she will read it over with the landlord,
Yep.
with the tenant. Both sides, whether or not you're
Agree to it,
represented
yeah.
by counsel, will get the opportunity to ask questions. They'll make sure you understand your obligations, your rights, and then once both sides say yes, we're in agreement, they'll sign that. The housing specialist will sign it, and then the housing specialist will take it to a judge,
Okay.
and then a judge will sign it, and that's huge.
Why?
Because once you get a judge's signature, it has the effect of a court order.
Okay.
So let's say your tenant agreed to vacate in 60 days, right? You signed it, your tenant has signed it, everybody's happy. Judge signs off on it,
Yep.
becomes a court order, that's fantastic. Day 61, the tenant's not moving
Okay.
and has no intention to move, right? So by signing that agreement, the parties understand, and again, a mediator, make sure that
Yes.
everybody is on the same page, but the parties give up the right to go to trial and go in front of a judge.
Okay.
So they give up the right to kind of, roll the dice
Yep.
in litigation. So back to my point, day 61 rolls around, that tenant's not budging.
Right.
All you have to do as a landlord is, if I'm representing you, you let me know. I file a motion. I mark it up for a hearing. The judge wants us back in court. Judge says,
How long would it take to get a hearing?
yeah, so it definitely depends on the housing court, which one you're in, and how busy the docket is. I would say,
How busy is the docket currently?
yeah, so right now, if we're talking about, Middlesex County, so that would be Northeast Housing Court, probably about 2.5 to 3 weeks.
Okay, that's pretty quick. I mean, that's not what
Right.
the common
Right.
myth is of, oh, gee, I'm not going to get in front of a judge for 6 months.
Right, absolutely. Especially because if there's a breach of this agreement, you're having me file a motion, that's a 30-minute motion hearing.
Yep.
It's not an all-day type of
Trial.
trial.
Right.
Exactly, exactly. And the thing about these agreements, judges really uphold them. They look to the four corners of the agreement. A tenant can say, well, I'm having, trouble in my personal life, I'm having trouble in my professional life. A lot of times, but if it's like you didn't vacate and you didn't pay when you said you were going to pay, you didn't follow this agreement, the judge really doesn't have too much wiggle room.
Right.
So I think these agreements are fantastic.
Yeah, it sounds like great advice for a landlord is to come to an agreement with the tenant,
Absolutely.
especially if you're rolling the dice with the trial, And the tenant may, if you've got a bad tenant and they misrent, by coming to an agreement, you're waiving the right to a trial.
Yes. And that is specifically spelled out in these housing court agreements. Every housing court, though it looks slightly different from housing court to housing court, they have forms that the housing specialist will either type electronically.
And I want to sidebar,
Sure.
just for a moment, for our guests and the people viewing. You notice what she just said? She said different housing courts have different forms and they change from different. You want to hire an attorney that handles evictions or wills or divorce, whatever it may be, that specifically handles these things, because they know each housing court is different. They know the players, they know the court people. It makes a huge difference. That's part of what we pay for when we hire a professional to take care of a specific issue. But I digress.
Absolutely.
So we go through those forms.
Right. So the form will say, some variation of, I understand that I don't have to sign this agreement. I understand I have the right to go in front of a judge, but I am choosing to resolve my case instead. So like I said, again, that's huge. A tenant then really would have a hard time saying, oh, but judge, I didn't know what I was signing.
Right.
Exactly.
Yes.
And especially, with the benefit of having a housing specialist mediator, it becomes even harder for a tenant to say, I didn't know what I was signing.
Right, it's like, wait a minute, they spelled this out for you and you signed it.
Right, in the mediation. It's not like, oh, my landlord's attorney called me on a random Tuesday and asked me to sign this paper.
Right.
That's, a little, that's iffy.
It doesn't cut ice.
Right, I would caution against doing that, and I would not do that, just as an attorney. That's not good practice.
Okay.
But when the mediator's there, it is really, really solid evidence that the tenant knows what they're signing, knows what they're agreeing to, and a judge will hold them to it.
Let's speed the process up a little bit, and let's say we're going to go to trial. They don't want to do mediation. We can't come to an agreement. Is the jury trial or just a judge?
Right. So in Massachusetts, tenants have the right to request a jury trial.
Okay.
Okay.
Is that 12?
So we're back up to 12-man juries.
Okay.
Yep. During COVID, it went down to 6. At this point, if a tenant does request a jury, and if the jury demand was made timely, a judge will likely ask, are we doing a 12-man or a 6-man? So you could waive the 12 and go down to 6, but let's just assume it's 12-person jury. So tenants, like I said, do have the right to request a jury trial.
Or they could just say, okay, I'm fine with the judge.
Correct.
Okay.
Correct.
What do you recommend?
So for landlords, I think bench trials in front of judges are usually the right way to go. And again, every case is different, so this is not,
of course.
This is not set in stone.
Right.
But
one size fits all.
Right. Nothing's ever one size fits all.
Right.
I do prefer for landlords bench trials just in front of judges, and that is because under current housing court procedure, let's say you go to the Tier 1 mediation, you can't come to an agreement, they usually schedule trial for about 2 weeks after that.
I see.
So it's it's moved along, whereas a jury trial, you could be sitting there for months and months before you ever see a jury, and then let's say you even get to court on the day of your jury trial. Housing court a lot of times will compete with superior and district court for jurors. So I've seen it.
So they're all pulling from the same pool.
Correct.
Okay.
Correct. So, and I think typically housing court gets the last pull.
Yep.
So, attorneys have sat in court till 2 p.m. and then
they don't have
an
any jurors
officer
left.
says there's no jury.
We can go home.
Come back in 2 months. Exactly.
Wow.
Exactly.
Okay.
So
let's just say the tenant has stayed past their welcome. We agreed on, a move-out date, and they don't stay. So we go back to the court and say, they're still here, we want to take the next step. What is that?
So the next step is you would file the motion, you get in front of the judge, and you say, Your Honor, I would like my execution. So your execution is...
Nobody gets
Right.
Sorry,
Exactly.
I have a dry sense of humor, everybody.
No,
Okay.
we're not doing that.
Okay.
An execution is the physical paperwork that is imprinted with the court seal on it.
Yep.
That the landlord or the landlord's attorney uses to hire a constable or sheriff. It's permission from the court
Yep.
to physically remove
Yep.
the tenant from the premises.
Okay, so if I understand correctly, you have a sheriff go with you, the owner, with some moving guys.
Correct.
And you move the stuff out.
Correct. And it's very important. I just do want to take this opportunity just to let everyone know, you really have to be careful when you're levying on an execution. So you want to make sure you're hiring a constable who is licensed in your jurisdiction, or using the sheriff's office. Your constable should work with you to locate movers who are licensed and bonded.
Okay. So not just have any random,
No,
your
do
brother-in-law
not. Absolutely
throw stuff in a truck.
Absolutely not. That is probably one of the worst things a landlord can do, especially when you're so close to the finish line. And I get it. It can be frustrating because sometimes you have to pay more for the movers who are licensed and bonded, but you want to protect yourself from that liability as much as possible. So again, your constable. You want to be if you're doing this by yourself without an attorney, you want to be asking your constable or sheriff, which movers do you hire, and then you want to go talk to those movers, make sure they're licensed and bonded. Do not hire your brother-in-law.
Right.
Do not hire your own van.
Yep.
Let the professionals
move the stuff, put it into a storage facility. How long does an owner have to pay for this?
So the owner's responsible during an execution for the constable or sheriff fee and for the mover's fees.
Yep.
The movers will take the tenant's possession to a warehouse.
Yep.
And again, there are regulations as to the parameters of the warehouse, which is, again, why I cannot stress enough, hire the professionals.
Right.
So once it gets to a warehouse, tenants can then access it one time for free to get things like sentimental belongings, things like that. And then from there, the warehouse will hold it for 6 months. Should the tenant not come back for the rest of their stuff, then the warehouse will start auctioning the stuff, and that'll be applied to the facility costs.
I see.
So it's almost like collateral, but
Well, it seems like the goal with all of this is finding a good tenant.
Correct.
And so that's when I come into play in screening a tenant. So thank you again for joining us.
Thank you for having me.
We learned a lot, and I definitely hope you come back and we can further this discussion.
I would love to, anytime.
All right. Thank you again.
Thanks.
And thank you for joining us. We'll see you next time on the Real Estate Forum.